Good morning. It's my great pleasure today to talk to Professor Nicholas Economidis from Stern Department of Economics. Nicholas is a world authority on network economics and policy. Technology regulation is on the forefront of news nowadays, and governments very involved in the US and Europe. So I wanted to ask you today to share your views on digital platform regulation from your research perspective, as well as implications to the policymakers.
Let me say about the regulation. Right now we have a number of authorities in the United States investigating Google, Facebook, Apple, and Amazon. And this is the Department of Justice, the Federal Trade Commission, Attorneys General of various states, plus the Judiciary Committee of Congress. So this is a lot of different bodies collecting information. So we need to be careful to distinguish between cases where there is a potential antitrust violation, and additionally there is a possibility with the present antitrust law for it to be addressed, and cases in which the violations are minor. So I think the most major issue, and that involves also privacy, is the way Google and Facebook collect information from users. If you use Google search or Chrome, automatically Google picks up your information. And what's that information? It's your IP address, your location, your zip code, all kinds of things that have to do with you, plus of course your search pages and what you're interested in, and similarly for Facebook. So this is an automatic default opt-in. So essentially they have combined two markets, the market for internet search and the market for personal information. So they put them in one, and for free you get search, and for free they get from you personal data. So these markets are really separate. And in principle, there are lots of people who might be willing to pay for search and not give their personal information. Or there might be others who are willing to give the personal information, but not for free. So they want to get paid. So this combination of the markets, this restriction, was imposed both by Facebook and Google, and has made what economists call a market failure. It's made this market fail because there is a single price, and that's the only thing you can get in that price. So this is a potential antitrust violation, and it can be, it can be investigated and possibly remedied. I mean, the government could come and say, look, I mean, this is not okay. You have to make the default be opt-out from collecting data. Then if people want to opt in, you can pay them something and they can opt in. And that's kind of a potential solution to this problem. Now, the European regulation for GDPR makes the default be opt-out, but for completely different reasons. They don't think of your personal data as a property, as your property. They think of it, the fact that you have privacy, as a fundamental right. And from their point of view, it's a matter of rights, not a matter of transactions and value and things that antitrust deals with. An investigation in the United States could produce a better solution than GDPR in the United States.
So it's very interesting you're saying the GDPR as a regulation focuses on rights, but one would potentially think of it as a market failure and focus on price as a regulatory mechanism. So what would be the kind of modifications that you would make to a regulation like GDPR? Because from what you said so far, the opt-out is a good thing, but then what would be the kind of modifications that you would envision to
Opt-out is a good thing, but it depends on the rationale. Yeah, because if the rationale is that there is a market failure, one of the objectives of antitrust authorities should be to restore the market. This is not the objective of GDPR. Their objective is to make sure that the rights of people are respected. But an American authority, for example, the Department of Justice, could come and say, look, we set the default to be opt-out, and then we make sure that the market works. Now, this market is hard to work right now because it's dominated by these two companies, Google and Facebook, which act as a monopsonist, that is, they are the single buyer of this information. And additionally, because they know so much about the user, they can act as an almost perfectly price discriminating monopolist, which means that they can offer you, since they know you, they will offer you a very specific price to buy your information, which is just for you, and they would offer me a different price, and so on and so on. So this is a serious issue in which there could be additional restrictions on Google and Facebook so they don't rip off the customers when the market actually works. So, and that's something way beyond the control or the scope of GDPR, because they don't involve prices, they don't involve competition, they don't involve markets. This is not their focus at all. But an American perspective on this could be quite different and could be more effective to restore the functioning market for personal information.
Would you then see potentially some competitors rising in such markets, the ones that are like...
I think that the main function of the browser of Google is to collect data. It's very hard. I don't know if you ever tried it. Try to delete your data from Chrome. It takes a number of different steps, maybe more than 12. That's very hard. On the other hand, there are browsers where as soon as you close the browser, everything gets erased. And these guys don't have an objective to sell you ads, and therefore they don't have a problem with that. So there is a lot of competition in browsers, and if people become aware of how much of their data is being collected, I think there would be more of a response. Some consumers don't care.
Yeah,
and then
that's the usual argument. People just don't care.
Yeah, they don't care. In my class, I asked them, how many of you keep cookies? 80% keep cookies. So obviously they don't care.
Yeah.
And that's fine, but there will be another part of the population, maybe older, maybe more mature, who would care. And they would say, look, I mean, this is a serious issue. Let's make sure that Google doesn't collect our data by default. We opt out. In any market, you would expect that some people are going to have a high willingness to pay, a low willingness to pay, or a high willingness to sell, low willingness to sell. So we want to see a functioning market, and that's normal. I think it would be normal.
You offered to comment a bit on Apple and Amazon, which I take a different set of problems. So
I think there are, it's not that there are no problems, but there are problems that even if Apple and Amazon were found liable for those problems, it wouldn't blow up their business model. They could fix them and live with a fix. What do I mean? Apple, the major allegation against Apple right now is that it monopolizes through its store the market for distribution of apps. So you cannot have an app on iPhone unless you go through the store, and the store collects 30% from the software developer. So there's a big suit against that, which had reached the Supreme Court on the issue of whether you buy from Apple or from the software developer. Now, believe it or not, this is a crucial issue for the antitrust thing. And in the end, the Supreme Court said, you buy from Apple, not from the developer. And now it has come back to the lower court to decide whether it is really a monopolization case and so on and so on. So, but I think that, well, suppose that my Apple loses the case. I mean, there will be ways to fix the distribution without killing the main Apple model. So that's why I think that kind of is a more minor issue. Similarly, against Amazon, there are complaints that Amazon promotes its own brands compared to the brands of third parties. Like I want to buy a memory stick, and Amazon says, here is this memory stick is endorsed by Amazon, is Amazon Basics or something like that. So, and that's kind of creating their own brand. Now, in my opinion, this is not the most crucial thing, because in many distribution channels, for example, in the grocery store, we see their own grocery stores brands. They're there. So you might make a case, well, this is not a typical grocery store, Apple is very big, and so on and so on. But again, there could be a case, maybe not the strongest case, but there could be a case against Amazon. Now, Can Amazon fix this? Sure. It's not such a big deal to kill all Amazon basics or Amazon brands, and So I don't think that this is a major impediment to Amazon, even if the allegation was brought against them and they lost.
Do you feel there is some need for regulation in a digital market like this as compared to a grocery store? Because I like this analogy. When I go to a grocery store, I see lots of products. Some of them are the store's brand. When I go to Amazon, all of my first page could very well be all Amazon brands with different labels, right? Sometimes they're innovative and they don't call it Amazon. Do you feel some regulation would be useful in there?
Is Amazon so big in terms of market share? Is it dominating electronic commerce? And therefore, like Microsoft was dominating PCs, we think it's a company that is obligated to follow extra requirements, and that question might come up in front of the regulators. Right now, it's a bit early because the regulators started collecting data, and we also are in an election year. So the most likely thing is that sometime in the coming summer they will come out with some reports that say, here is the problems we found, and we're going to start pursuing them, but then they will wait until the election, see who gets elected and what's the new Department of Justice, how does it change, and so on and so on.
But from what I understand, you're saying is that it is almost like an empirical question, as we say in research. It's a question of like data about the market dominance, the options. So in my mind, for example, if you look at Apple platform, there is at least Google, right? So in the sense, you could say we can count what is the dominance of Apple in the app space and make some argument about that.
That's right, but at the same time, according to American antitrust law, it doesn't matter that there is competition between Apple and Android. If you have Apple, you have to use this the store and the apps, and therefore the competition with Android doesn't matter. Now, that's not the same with Amazon, because you would say, okay, we have distribution. Amazon has different market shares on distribution of different things. For example, in ebooks, they have 85%. In apparel, they have 50%. In other things, they have different percentages. So American antitrust law is written in such a way so that the government can even bring a case market by market.
Oh, I see.
They would say, look, I mean, we think that you're violating the law in the ebooks market, or we think you are violating the law in the distribution of apparel, and maybe you're not violating in distribution of computers, but it doesn't matter. We can bring the cases on this. So that's why this kind of grand investigations are troublesome for companies, because they really don't know where they're going to be hit.
Okay. They might think it A and it turns out to be B.
Yes, and I'm not part of the investigation. I should say for the camera that I don't work for any of these people.
Can I ask you to comment more broadly on this notion of breaking up these companies? We need to break them up. And it reminds me of the Microsoft debate that you were part of many years ago about breaking Microsoft up. So what about breaking things up?
I think that the comments by the politicians are populist and a bit naive, I have to say. Especially for the politician who is a law professor, this is inexcusable, because he's a law professor, he's supposed to know what the law is. So breakup is an extreme measure, a draconian measure. And the way American antitrust law works, it can only be applied in very extreme circumstances. I think that present law is unlikely to result in breakups. Even Microsoft, which was for sure found liable for monopolization, even though the district court said, oh yeah, breakup. The Department of Justice said breakup, district court accepted breakup. When it went on appeal, the appeals court said, look, I mean, there is all these other things that Microsoft can do to fix things. And what ended up is an implementation of these business remedies or conduct remedies, which has lasted up to today. They still make meetings to make sure that Microsoft is compliant, but it didn't result in a remedy. So people have to be a bit more careful. I think it's one thing to be a candidate. It's one thing to say things as a candidate. It's a different thing to be a president or an elected representative, and you pass a new law, or you implement a new law.
Interesting. So what you're saying, in some sense, what we learned from Microsoft case, but also there's a list of remedies, some that we talked about today, that should be tried first.
Absolutely. And they have to be proportional to the violation.
Right.
I mean, suppose you cross the road illegally. That's a small violation. I mean, you get a fine, right? They don't put you in jail.
Right.
So it's a different thing if you had a big violation, then you have a proportionally larger penalty. And a lot of this idea of how proportional they are and how big they're supposed to be comes from a long history of enforcement. The American antitrust law, the way it was written right after the Civil War, is very vague. It doesn't say, oh yeah, I mean, this is a real, for sure, a problem, this is not for sure a problem. It's pretty vague. And it's good that it was vague, so it can be applied to many different industries. I never thought of digital economy at that point in time. Right? Of course not. But at the same time, it can be applied because we have a history, a long history of decisions and of understanding of what is normal or what's kind of expected versus what is a weird aberration.
Like egregious violation.
And yes, I mean, how far should the violation be? How extreme does it have to be to require a breakup, for example? I mean, it's not out of the question that a breakup might be the right solution, but you have to have a very, very extreme violation.
Very interesting. Well, thank you very much for taking the time. It's great to hear the sort of research-based, theory-based understanding of such complex phenomena.
And let me thank again the Fubon Center for supporting the Net Institute conference. We give grants for people to do unrestricted research in this area, and we bring them back here at Stern to actually present. And we have been doing this for now 17 years.
Wow.
I'm almost self-congratulating myself that we managed to actually do that.
I would like to join you in congratulating you on running this successful conference with deep academic contents. And I hope you continue. It's our pleasure as a Fubon Center to support your efforts. And thank you very much.
Thank you again.